A couple of days ago in its basketball coverage, ESPN had what they called crossover, when they had people who normally do their NBA games doing college games and announcers who normally do the college games doing NBA games. Normally when I've been at this conference, I've been involved not on the theory-type papers, but on the non-theory-type papers. This time I've been recruited to talk about a theory-type paper, so I'm engaged in crossover. One of the people who was doing crossover was Bill Walton. Normally does the college games, was doing an NBA game. So if I say something like, "Throw it down, big guy," or start talking about the Grateful Dead, that's what's going on here. It's crossover. Jack asks us to think about rhetorical topics and construction and dealing with constitutional, as I say, constitutional uncertainty. It seems to me that the topics provide a means of understanding a phenomenon in constitutional practice that's quite important, at least understanding it. The phenomenon is subjectivity. How is it that different deciders, different interpreters come to different conclusions, even if they think that they're all trying to do the same thing? And in particular, how is there the kind of subjectivity in which people's conclusions about the Constitution and application of the Constitution to particulars reflects their own views of sound policy, considerations like that, politics if you like. The explanation I'm going to try to give, which is related to the topics, isn't crude legal realism. Well, if people have power, of course, they're going to do what they want with it. It is something else. Because the thing about the topics, as Jack says, is there are so many of them. A topic is anything that is a reason that might move someone either to reach a conclusion or to make a decision, to decide what action to take. There are a whole lot of topics. And there is a great deal of agreement, I think, that a lot of topics are valid considerations, as Jack says. That is to say that they matter. But what there isn't is agreement about how much different considerations like this matter and what to do when they push in opposite directions. That combination of agreement about relevant factors and lack of agreement about how the factors work together, what their weight is, for example, I think has a lot of explanatory force in constitutional practice, and as I say, explains forms of subjectivity, and in particular, a lot of what we think of as constitutional doctrine. I'll give a couple of examples drawn from originalism, two classic kinds of originalism. First, Robert Bork's originalism with respect to the First Amendment, which is not the kind that is largely practiced these days by textualists. Bork thought it was possible through structural reasoning to identify goals that the Constitution required be followed in order to create the kind of structure that the Constitution is designed to create, a functioning democracy. Bork thought that those goals had important implications for freedom of political speech. And Bork was explicitly engaged not in what he called construction, but I guess what would be called construction today, or at least the formulation of doctrine. His view was that the Constitution, and Bork basically applied to constitutional law a way of thinking that he'd earlier developed for the Sherman Act, that the Constitution, here the structure, provides a value that must be served, and that it is left to decision makers, frequently judges, to devise some doctrine which might change over time as the circumstances in the world change, that will cause the value to be achieved. That approach requires both in identifying the value and then in identifying some set of judicial doctrines that will implement the value, requires consideration of a great many different features of the Constitution, different factors, different, Jack would say, a lot of them are topics, without providing any way of deciding, well, when they conflict, when they point in opposite directions, what is to be done about resolving the different tugs. Bork thought it was possible to do that, but I think didn't deny that different decision makers would reach different conclusions, And I think the ultimate reason for that is that kind of process, trying to identify the value first, when there are a lot of different pieces of evidence about exactly what the constitutional democracy in the Constitution is, trying to identify the value, and then, in the real world, trying to formulate principles that will lead to the achievement of that value. Both of those require that the decision maker call on a multiplicity of considerations and factors, and they don't give any more guidance about how to resolve inconsistencies or pushes in different directions other than this is what you're trying to accomplish. Similarly, more conventional textualist type originalist reasoning involves the same kind of problem of being able to identify multiple considerations without having any commonly accepted theory about what to do with the multiple considerations, what to do with the multiple topics. In understanding what we might think of as just interpretation, that is to say, taking a text, and here I've moved on from Bork's basically structural thinking to, as I say, more conventional textualist-oriented thinking, taking a text at some level of abstraction and not initially applying it to particular facts, but finding also at a fairly high level of abstraction the text's implication for some question, like, for example, the recess appointments clause. Does a recess within the meaning of the recess appointments clause include a break in a session of the Senate? Answering questions like that require thinking about a great many facts having to do with the meaning of words, ways in which they connect to one another, in which the structures that words create in a government operate. Multiple factors are going to bear on that, but the weighting among the factors is something individuals will differ on and that the commonly shared theory does not provide an answer to. Same thing happens when concepts are being applied to particulars. Okay, here is a generalization, here is a particular set of facts. Routinely, the way concepts operate is to identify some paradigmatic case. Well, the paradigmatic case will have various features. There will be an actual case that has different features, and the question is, does the actual case fall within the concept? Well, the concept has a lot of different characteristics that identify it, and the availability of the characteristics doesn't say, well, if this particular characteristic is present or absent, how much does that count in favor of classifying something in or out of the concept? Familiar feature of the way concepts operate, of the way people think, and another demonstration of why people are going to differ from one another, simply because the resources that are available, the topics or however they're to be characterized, the resources that are available are useful but limited, and in particular do not provide the answer when they push in opposite directions what's to be done. Same thing happens in the formulation, once again, of doctrine. Doctrines use, judicial doctrines, and there are some non-judicial doctrines, but the ones we think about the most are judicial doctrines. Judicial doctrines use generalizations to decide in the face of uncertainty. Classic example, we were talking about this last night, the original package doctrine. States can't tax imports, but states can tax property that is physically present in the state. When does some physical object that has been brought into a state cease to be an import and become simply part of the property of the state? Supreme Court in the early 19th century announced the original package doctrine. As long as it is in its original package, the court, alas, has subsequently abandoned the doctrine. As long as it's in its original package, the item is an import and can't be taxed. That is a way of dealing with uncertainty in application. Is that really 100% true? Probably not. But courts and other decision makers have to decide under uncertainty, and one way to decide under uncertainty is to adopt a generalization that's accurate enough and proceed with that, because you're not going to be absolutely accurate all the time. The problem with generating generalizations, and this I think is true of judicial doctrine generally, generating generalizations to deal with uncertainty is that deciding which generalization to use requires, and this brings in a lot of subjectivity, and in particular the kind of subjectivity in which people look to consider their own concerns and views about public policy. deciding what generalization to use when you know that the generalization will make mistakes requires weighting different kinds of mistakes. Is it really, really, really bad to allow a state to tax an import? If it's really, really, really bad to allow a state to tax an import, then maybe the original package doctrine is too permissive, and maybe something a lot stronger should be used. On the other hand, if it's really, really, really bad to interfere with the state's power to tax, then maybe the original package doctrine is too restrictive, and some other implementation to be used in the light of uncertainty, because again, even after you've thought all you can about application, it's likely that there will still be substantial uncertainty. Maybe some other generalization should be adopted. The choice among generalizations is based on trade-offs, is based on weighting of different considerations, and once again, the structure arises in which there will be a lot of agreement as to what considerations are relevant in formulating a doctrine, but the strength of the different considerations will not be generally agreed on, and therefore different decision makers, because they have different weights on the strengths of different considerations, will formulate different doctrines. Doctrine then turns into what we know as judicial doctrine through the operation of another and similar process, which is stare decisis. Stare decisis is a practice courts have to decide in the face of uncertainty. One way to decide in the face of uncertainty with reasonable expedition, with reasonable predictability, is for courts to follow their earlier decisions, either their own earlier decisions or the earlier decisions of higher courts. Different forms of the principle of stare decisis will reflect different weightings of the considerations about the cost of different kinds of errors. And in particular will reflect the weighting on the costs of errors in the light of the need for predictability and uniformity. People will put different weights on those considerations. They will have stronger or weaker forms of stare decisis. Those will reflect the decision maker's views, which will differ from one decision maker to another, about which kind of error is most important to be avoided. So a process of just decision under uncertainty is going to generate certain standard forms of subjectivity, and in particular, standard forms of decision maker policy making that seems to me to be probably unavoidable. And the last thing I'll say about that, sort of having sketched how I think that these different considerations lead to subjectivity, that Jack talks about the topics as a solution to this. I think what the topics do is point out the problem. That is to say, they show why there is subjectivity. They show why, in the face of decision, inevitably in the face of uncertainty, there will be subjectivity. There might be something that looks a great deal like policy making by people who are implementing rather than the primary policymakers. I think that's an explanation of a lot of what goes on in American constitutional practice. Whether it's a solution rather than an explanation, I think is a harder question.
Topics, especially as they become further elaborated over time, serve two functions. One, we might say they're time-saving and they're community related. That is, time-saving is I don't have to reinvent the wheel. Someone else has already told me how to solve this problem. I can start with these ideas in order to solve the problem. Community is that, and this is especially true with respect to doctrine, there's already some degree of agreement, even at a shallow level, that this is an appropriate way to solve this particular problem. I don't have to. I can build on the fact that let's take Youngstown as a topic for executive power. I can build on the fact that Youngstown is a generally recognized way of analyzing a separation of powers problem and then reason from it, and then I and my audience are presumed to share the assumption that this is an appropriate way to analyze and solve this particular problem. But let me make a point about originalism. Originalism can be understood in this sense as a perpetual feedback mechanism for interrogating the existing set of topics that we've used over time to solve particular problems. That is, you can understand originalism as a reform program. That is, we have a set of solutions that we've come up with over the years to solve various constitutional problems. Perhaps over time, the set of solutions built on the set of solutions has strayed from what we think constitutional fidelity requires. One way of understanding the project of originalism is as a corrective to a particular set of solutions that are time-worn and have been adopted by folks at different points to say, no, you've strayed from the path. This is incorrect. Now, of course, it's true that originalist arguments themselves are structured in terms of topics, but that's simply because they're appeals to an audience based on common presuppositions. But it also shows you that originalism has a very distinctive flavor to it, a distinctive ethos to it, which can be cashed out in terms of the way it interacts with ideas of topics.